Hi. Let's go ahead and do 8 minutes at 2:40 for some endurance and some speed. 8 minutes at 2:40 jury charge. Ready to write. Members of the jury, you have seen and heard all of the evidence and arguments of the attorneys. Now I will instruct you on the law. You have two duties as a jury. Your first duty is to decide the facts from the evidence in the case. This is your job and yours alone. Your second duty is to apply the law that I give you to the facts. You must follow these instructions even if you disagree with them. Each of the instructions is important and you must follow all of them. Perform these duties fairly and impartially. Do not allow sympathy or prejudice to influence you. You should not be influenced by any person's race, color, religion, national ancestry, or sex. Nothing I say now and nothing I said or did during the trial is meant to indicate any opinion on my part about what the facts are or about what your verdict should be. In this case, the defendant is the United States of America. The United States is liable for injuries caused by the negligent acts of any employees of the government acting within the scope of her employment. All parties are equal before the law, and individual is entitled to the same fair consideration that you would give to the United States of America and vice versa. The evidence consists of the testimony of the witnesses, the exhibits admitted in evidence, and stipulations. A stipulation is an agreement between both sides that certain facts are true. In determining whether any fact has been proved, you should consider all of the evidence bearing on the question, regardless of who introduced it. You should use common sense in weighing the evidence and consider the evidence in light of your own observations in life. In our lives, we often look at one fact and conclude from it that another fact exists. In law, we call this an inference. In inference, any inference you make must be reasonable and must be based on the evidence in the case. Certain things are not to be considered as evidence. I will list them for you. First, if I told you to disregard any testimony or exhibits, or struck any testimony or exhibits from the record, such testimony and exhibits are not evidence and must not be considered. Second, anything that you may have seen or heard outside of the courtroom is not evidence and must be entirely disregarded. Third, questions and objections or comments by the lawyers are not evidence. Lawyers have a duty to object when they believe a question is improper. You should not be influenced by any objection, and you should not infer from my rulings that I have any view as to how you should decide the case. Fourth, the lawyer's opening statements, interim statements, and closing arguments to you are not evidence. Their purpose is to discuss the issues and the evidence. If the evidence, as you remember, differs from what the lawyer said, your memory is what counts. You have heard the phrases direct evidence and circumstantial evidence. Direct evidence is proof that does not require an inference, such as the testimony of someone who claims to have personal knowledge of a fact. Circumstantial evidence is proof of a fact or a series of facts that tend to show that some other fact is true. As an example, direct evidence that it is raining is testimony from a witness who says, "I was outside a minute ago and I saw that it was raining." Circumstantial evidence that it is raining is the observation of someone entering a room carrying a wet umbrella. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You should decide how much weight to give to any evidence. In reaching your verdict, you should consider all of the evidence in the case, including the circumstantial evidence. You must decide whether the testimony of each witness is truthful and accurate in whole, in part, or not at all. You also must decide what weight, if any, to give to the testimony of each witness. In evaluating the testimony of any witness, including any party to the case, you may consider, among other things, the ability and opportunity the witness had to see, hear, and know the things that the witness testified about, the witness's memory, any interest, bias, or prejudice the witness may have, the witness's intelligence, the manner of the witness while testifying, and the reasonableness of the witness's testimony in light of all the evidence in the case. A deposition is the sworn testimony of a witness taken before trial. The witness is placed under oath to tell the truth, and the lawyers for each party may ask questions. The questions and answers are recorded. The deposition of Michael Scott, which was taken on September 20th, 2004, is about to be presented to you. Deposition testimony is entitled to the same consideration and is to be judged insofar as possible in the same way as if the witness had been present to testify. The law does not require any party to call as witnesses every person who might have knowledge of the facts related to this trial. Similarly, the law does not require any party to present as exhibits all papers and things mentioned during this trial. In considering the evidence, you may find the testimony of one witness or a few witnesses more persuasive than the testimony of a larger number. You need not accept the testimony of the larger number of witnesses. It is proper for a lawyer to meet with any witness in preparation for trial. You have heard witnesses give opinions about matters requiring special knowledge or skill. You should judge this testimony the same way that you judge the testimony of any other witness. The fact that such person has given an opinion does not mean that you are required to accept it. Give the testimony whatever weight you think it deserves, considering the reasons given for the opinion, the witness's qualifications, and all of the other evidence in the case. You may consider statements given by Jose or Beatrice under oath before trial as evidence of the truth of what he or she said in earlier statements, as well as in deciding what weight to give to his or her testimony here in court. With respect to other witnesses, the law is different. If you decide that before the trial one of the witnesses made a statement that is inconsistent with his testimony here in court, you may consider the earlier statement only in deciding whether the witness's testimony here in court was true and what weight to give to the witness's testimony here in court. In considering a prior inconsistent statement, you should consider whether it was simply an innocent error or an intentional falsehood, and whether it contains an important fact or an unimportant detail. The parties agree agreed that the summary of Jose's medical bills accurately summarizes the amount of his medical bills for medical care and treatment received arising out of the collision. You should consider these summaries just like all of the other evidence in the case. Any notes you have taken during this trial are only aids to your memory. Your notes are not evidence. If you have not taken notes, you should rely on your independent recollection of the evidence and not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than the recollection or impression of each juror about the testimony. When I say a particular party must prove something by a preponderance of the evidence, or when I use the expression if you find or if you decide, this is what I mean. When you have considered all of the evidence in the case, you must be persuaded that it is more probably true than not true. When I use the words intelligence in these instructions, I mean the failure to do something which a reasonably careful person would do, or the doing of something which a reasonably careful person would not do under circumstances similar to those shown by the evidence. The law does not say how a reasonably careful person would act under those circumstances. That is for you to decide. When I use the words ordinary care, I mean the care a reasonably careful person would use under circumstances similar to those shown by the evidence. The law does not say how a reasonably careful person would act under those circumstances. That is for you to decide. It was the duty of the plaintiff before and at the time of the occurrence to use ordinary care for his own safety. The plaintiff is contributory negligent if 1. He fails to use ordinary care for his own safety, and 2. His failure to use such ordinary care is the proximate cause of the injury. The plaintiff's contributory negligence, if any, which is 50% or less of the total proximate cause of the injury for which recovery is sought, does not bar his recovery. However, the total amount of the damages to which he would otherwise be entitled is reduced in proportion to the amount of his negligence. This is known as comparative negligence. If the plaintiff's contributory negligence is more than 50% of the total proximate cause of the injury for which recovery is sought, the defendant shall be found not liable. It was the duty of the defendant before and at the time of the occurrence to use ordinary care for the safety of the plaintiff. That means it was the duty of the defendant to be free from negligence. When I use the term proximate cause, I mean any cause which, in natural and probable sequence, produced the injury complained of. It need not be the only cause, nor the least, last, or nearest cause. It is sufficient if it concurs with some other cause acting at the same time, which in combination with it causes the injury. When I use the expression contributory negligence, I mean negligence on the part of the plaintiff that proximately contributes to the cause of the alleged injury. It is the duty of every operator of a motor vehicle using a public highway to exercise ordinary care at all times to avoid placing himself, others, herself in danger, and to exercise ordinary care at all times to avoid a collision. There was forced in the state of Illinois at the time of the occurrence in question a certain statute which provided that a vehicle shall be driven as nearly as practically entirely within a single lane, and shall not be moved from such lane until the driver has first ascertained that such movement can be made with safety. If you decide that a party violated the statute on the occasion in question, then you may consider the fact gathered together with all the other facts and circumstances and evidence in determining whether and to what extent, if any, a party was negligent before and at the time of the occurrence. There was in force in the state of Illinois at the time of the occurrence in question a certain statute which provided that an electric turn signal device must be used to indicate an intention to change lanes. If you decide that a party violated the statute on the occasion in question, then you may consider the fact gathered together with all other facts and circumstances in evidence in determining whether and to what extent, if any, a party was negligent before and at the time of the occurrence.